Welcome to the Mulcahy Law Firm podcast. For over 25 years, Mulcahy Law Firm has helped plan communities and condominium associations throughout the state of Arizona. Please go to iTunes or your favorite podcasting platform and leave us a rating and a review. Thank you for listening. Here's Beth Mulcahy.
Good morning, everybody, and welcome to class number 11 of our firm's 2024 Virtual HOA Academy in partnership with the cities of Avondale, Chandler, Glendale, Goodyear, Mesa, Peoria, Phoenix, Scottsdale, Surprise, and Tempe. My name is Beth Mulcahy, and I'm the managing partner and senior attorney for the Mulcahy Law Firm in Phoenix, Arizona. I've enjoyed representing HOAs and condominiums for 28 years. My firm currently represents over 1,000 planned communities and condominium associations throughout the state of Arizona. And I also currently serve on my HOA board and have for many years. In today's class, we're going to be discussing how HOAs and condominiums can handle two common issues: rental properties and parking issues. As always, we'll have a free Q&A session at the end of the class. Right now, a poll was launched at the beginning of the session, and some of you will see it on your screen if you're joining us here on Zoom. For those of you who are here with us on Facebook Live, we're going to be asking you two questions for today. The first question is going to be, what city do you reside in? Or what city is your HOA or condominium in Arizona in? And the second question is, let us know your current role in the association. Are you a board member, a homeowner, manager, or other? This class is going to be conducted just the same way that we conducted all of our other classes throughout the past 10 months in 2024. As always, feel free to submit your question in the Q&A box on Zoom or in the comment section on Facebook Live. And all questions will be answered today at the end of this session, which will likely be right at 12 o'clock noon. Quick friendly reminder, today's session is limited to one question per attendee. So thank you for understanding. Looks like we've got our poll results back. So I'm going to go ahead and go through them real quickly. We have 1% of you here from Avondale. Let's see. We have 14% from Chandler, 3% from Glendale, 5% from Goodyear, 21% from Mesa, 8% from Peoria, 12% from Phoenix, and 23% from Scottsdale. We have 7% from Surprise and 5% from Tempe. So really great turnout. It's not very often that we have we do have every city represented here today. So great job to all the cities about getting the word out about the classes here today. We also have our second poll question, which is let us know your role in the community. And we have 75% of you here today are board members, which is amazing. 7% are community managers, 16% are interested owners, and 1% are others. So that's great news. So thank you so much, everybody, for being here today. Looks like we have over 100 attendees already, which is amazing. Looks like about 114 here just as we're getting started on our presentation. So thanks, everybody, for being here. Let's start out quickly with a quick update on the Corporate Transparency Act. This is probably like the hottest topic right now in our industry. I know we're getting calls all week this week, all week last week regarding, Corporate Transparency Act, and some associations are growing very concerned that they haven't maybe complied with it yet. So let's just kind of start out and give you a quick overview of the Corporate Transparency Act and talk about the important deadline, which is coming up December 31st, 2024. So what is the CTA? It stands for the Corporate Transparency Act. It was a federal law passed in 2000 to track criminal or terrorist money laundering. The goal of the CTA, the Corporate Transparency Act, was to safeguard national security and the U.S. financial system. So does it apply to HOAs and condominiums in Arizona and throughout our country? The short answer is yes. Associations that are actively tax exempt under 501c4 of the Internal Revenue Code, or associations with more than $5 million in annual gross receipts and more than 20 full-time employees. So many HOA and condo industry professionals throughout the U.S. sometimes are saying, hey, we don't think that the intent of this law was that it was, to have HOAs and condominiums apply to them, because, obviously we never hear anything about criminal or terrorist money laundering in an HOA or condo. But for now, even though there have been some legislation that was recently introduced in the United States Congress, and then also there's a couple of cases that we are tracking federal cases trying to determine if HOAs and condominiums, this law applies to them. As of right now, it does apply. And we are advising all of our clients and any association that's contacting us to please comply with the Corporate Transparency Act. So what exactly do you have to do to comply with the Corporate Transparency Act? You have to fill out a form, and it's basically, they've set up a whole website to accept these forms. And basically you just have to get the business name of the association. You have to get the following information for all board members. So the legal names, their birth dates, their home address, and driver's licenses, state IDs, or passport numbers. We also have to get that same information for individuals with substantial control over the association. Kind of unclear who this would be under the CTA, but many management companies are stepping into this role if they're managing an association and filing that information on behalf of the management company. This isn't an ongoing reporting requirement, so all of the applications are due. The forms are due by December 31st, 2020, really starting to butt up on this federal law, and the first part of it becoming due, all the forms needing to be filed by in about a month. But any changes that you may have to your corporation must be updated. You must update that information. And so basically how it works is that within 30 days of any changes, like a typical change would be, hey, the board changes. We have somebody resigns, or somebody quits, or somebody gets removed from office. It's a board member. Or maybe we have an election and new board members are elected. Or maybe your address changes. All of this would be something that would need to be updated with the federal government via the Corporate Transparency Act. And so there are some pretty serious penalties if you don't comply. I'm not saying this to scare you, but I'm just letting you know, hey, this is a serious law with serious consequences. The civil penalties are $500 per day, and the criminal penalties are up to $10,000 and a maximum of 24 months in prison. So federal government is not fooling around with this law. All associations in Arizona do need to comply with it, as long as they are tax exempt under Section 501c4 of the Higher Internal Revenue Code, which is probably like 99% of associations in Arizona. So we're going to do just a quick little poll question. And so we launched it on our screen, and it just basically, we're just curious where everybody is on the CTA right now. So it looks like so we have about 100, and I'm not sure how many people, but about 120 people that are on this call right now. And those of you who have complied with this, the question is, has your association filed its initial CTA beneficial ownership report under the CTA? So we have 26% that say yes. So great job. We have 47% that say, no, we haven't done it yet, but we plan to. 7% say, no, we haven't done it, and I'm not sure about the plan. And then 20% of you just say, I'm not sure, maybe this is the first time you're hearing about it. So we have about 131 people here on this call today. So just kind of some closing remarks on the CTA. It's something you have to comply with. Our firm is helping many associations to comply with the CTA, and we've heard from many associations that they need help. And so our firm has stepped in, and we've decided to accept anybody who needs help filing their CTA reports that are required. We're going to continue to accept the CTA, people hiring us to help them with their CTA. But really, everything needs to be in as soon as possible, like starting probably December 15th. We're not going to be being able to accept new people asking us to help them with this. So make sure that you are providing that information to us if you are interested. We have a CTA filing information sheet to help you get the process started, and our office is going to be sharing that with you. And we've also prepared a CTA frequently asked questions sheet that my office is also going to be sharing on Zoom and on Facebook Live too. One last thing we have, if you want to hire us to do this, you have to submit a signed representation and fee agreement. And we need that by November 30th if you're interested in us helping you on this. So lots of deadlines coming up, not panic, but this is a serious law that we all need to comply with, myself included. My firm needs to comply with it. I'm also a board member, so I'm going to be complying with that with 2 different associations that I'm a board member for. So it's something that we all need to do, and it needs to be done by December 31st. And with the holidays in late December, this is not something you can wait on. So if your association needs help on this, get the word out that our firm can help you, and contact our office to line up to have us help you file the paperwork that you need to do. Okay, now let's go on to our main event for today. We're going to be talking about rental properties and how to effectively work with rental properties. I think we can all agree that over the past 7 or 8 years, there's been really a dramatic increase in the number of rental properties in Arizona. And this is largely a result of a lot of these short-term rental companies coming in, VRBO, Home Away, and they are providing nightly, weekend, less than a month rentals in Arizona. But we also always have had seasonal rentals in Arizona. And of course, there's a very strong rental market for longer than seasonal rentals for people who are, maybe unable to afford a down payment on a house or who just want to rent because they don't want the hassles of home ownership. So oftentimes we hear from board members and property managers about problems and issues with rentals. And especially since the short term rental industry has really kicked off in Arizona and has created a lot of short term rentals in our state. And so what we decided today was we would just give you just a quick primer about, okay, what is the law in Arizona that talks about short term rentals and rental properties in general? And then let's give you some suggestions on how to best manage problems that may come up with rentals. So let's start out and just talk a little bit about what are the laws in Arizona on rental properties. So back in 2014, so 10 years ago, our legislature enacted some different requirements about rental properties in Arizona. And so kind of the most important one is that unless rentals are prohibited in your association's declaration, owners can rent their property. But your CCNRs or your declaration can have rental time restrictions in the declaration. So let's give an example. So if your association CCNRs or declaration don't say anything about rental properties or being able to rent, that means that your association members or owners can rent the properties without any restrictions. If your documents say that there's like a minimum 30-day rental period, then owners would need to comply with that. And so that's kind of the first part of the law. That was a major shift 10 years ago when this occurred. A second thing that was kind of an important shift is an owner can designate a third party agent to be their agent with regard to the rental property. So if an owner maybe lives in Canada or in Wisconsin and they want to have somebody on the ground in Arizona who's managing their rental properties, they can appoint a person to be their designated agent, so to speak. And that person can act as that owner's agent regarding any association matters pertaining to the rental of that unit. That designated agent, however, cannot vote as an owner in the association. What we recommend is if you have an owner that wants to do this designated agent thing for their rental property, what I would recommend is just continue to copy the owner, but then also be sending a copy to the designated agent so that, the agent and the owner are aware of any issues that are going on with regard to the property. Okay, the third kind of important part of Arizona law pertaining to rentals is that the association can only ask for certain information from a owner regarding a tenant in their property. And it's very limited what we can ask for. So I want to make sure we go over that. So, and this, supersedes anything that you may have in your documents or any rules you have on this. This law says this is all you can ask for of any owner who's renting their property. So number one, we can ask for the name and the contact information for any adults that are occupying the unit. Number two, we can ask for how long the lease is, including the beginning and ending dates of the lease. Third, we can ask for a description and the license plate numbers for the tenant's vehicles. And fourth, only if you're an age-restricted community, meaning like a 55 and over community, we can ask the owner, the owner's agent, or the tenant must provide the association or its manager with the government-issued identification with the photograph of the tenant and confirmation that the tenant meets the minimum age restriction. So again, the only things that we can be asking owners who are renting their units regarding their tenants are going to be the name and contact information for the adults occupying the unit, how long the lease is, and this description of the license plate numbers and the tenants, a car description and the license plate numbers of the tenants' vehicles. If you're 55 and over community, we can ask that they provide proof of age, that they're over 55. And so that's kind of a change. A lot of associations have something in their documents that may say that you can get a copy of the lease agreement or the rental agreement. This law does not say that that is something that the association is allowed to make it mandatory to provide. So if you're asking for that now, that's not something under the law that you can ask for. So be careful about that. One other thing that the association can do is they can charge a small fee, a very small fee, for an owner to provide information about their tenant. And that fee is not more than $25. And so for each tenancy, each change in tenancy, when you ask for this information, if the association wants to, they can charge $25 per change in tenancy. And that $25 needs to be paid within 15 days after a postmark request from the association for this information. It cannot be charged if the tenant is renewing their lease. The same tenant is just kind of renewing their lease year to year. But it can be charged for each change in tenancy, so each new tenant that moves in. If the association doesn't receive the $25 from the owner, we do have some remedies. We can charge a late fee and at $15, that's it. But we cannot fine an owner that's renting their property for not providing this information to us. So we could charge a $25 fee. If they don't pay it within 15 days of a postmark request for that information, we can charge a $15 penalty for them not paying it or providing the information to us. A couple of kind of practice pointers on this are some things that we can't request the landlord owner to provide to us, cannot. So we can't ask for the rental application by the tenant. We can't ask for a credit report for the tenant. We already talked about the fact that we also can't ask for the copy of the lease or the lease agreement or the rental contract. We can't require the tenant to sign a waiver or other document limiting the tenant's due process rights as a condition of the tenant's occupancy of the rental unit. I honestly don't know why the legislature put that in there in the law, because the tenant doesn't have any due process rights. In Arizona, only the owner would have a right to a hearing, if there was a fine or something that was levied against the owner. So it's kind of nonsensical, but I'm mentioning it anyways, just in case something like that comes up. The third thing that we are prohibited from doing would be prohibiting or otherwise restricting an owner from serving on the board because the owner is not an occupant of the unit or the lot. So if the owner is renting the property, we can't say you can't serve on the board. Another thing that we can't do is impose a penalty of more than that $15 for not providing the information about the tenant and paying the $25 fee that we talked about a few minutes ago. And then any attempt by the association to exceed the fees that are permitted under the statute, so that $25 fee and then the $15 late fee if they don't pay, voids the fee entirely. So, it's kind of crazy because it's only $25 plus 15, but they're very strict under the law. These statutes, however, in Arizona do allow the association to enforce any provision in the governing documents that restricts the residency of persons who are required to be registered as a level 2 or 3 sex offender. One of the really interesting things about having a long legal career in our profession is that I've kind of seen the law evolve on this over the years. And when this was passed 10 years ago, it was kind of shocking to me that they put in this rental law that we can put something in our CC&Rs that prohibits level 2 or 3 sex offenders from living in the association. And I look back on that time when the legislature was coming up with this law, and it's kind of like a deal was made, I would say, because some associations were very concerned about level 2 and 3 sex offenders moving into the association. And I think this was kind of thrown into this law to appease some of those constituents. We haven't seen any associations that have actually passed an amendment to their CC&R saying that level 2 and level 3 sex offenders can't live in the association, whether as owners or as tenants. So it'll be interesting to see what happens if anybody should take this step in the future. I think there's some definite constitutional challenges that could be made against the association if they do try to pass something like this and enforce it. So we're really not advising associations to do that, but it's part of the law, so I wanted to mention it to you. Another really kind of interesting thing, and I have used this quite a bit, and it's something that we can use against landlord owners who have bad tenants in their property. And I'm sure some of you have that right now. I probably get 1 or 2 calls a week dealing with bad tenants in a property, and how can we best manage that with the owner? kind of an interesting part of this law that helps us on that is an owner of a rental property in a condo or a planned community is required under the law to abate or stop criminal activity in the unit or lot under Arizona Revised Statute 12-991, because any residential property that is regularly used in the commission of a crime is a nuisance. So, very interesting, this part of the law that allows us to penalize criminally an owner for behavior of the tenant if they're basically engaging in criminal activity. So, if you have a tenant that is dealing drugs, or maybe you've got like a drug SWAT team coming in, or maybe there's other criminal activity going on there. And I mean, I've seen a lot of different things over 28 years where we have SWAT teams coming into properties or the DEA agents coming in and surrounding the unit, taking somebody out. If the owner is aware that behavior is happening in their unit or their lot and they don't do anything about it, we can, under this statute in Arizona, criminally pursue that particular owner. And surprisingly, we have seen this twice. I've seen it twice in 28 years, where it's usually like a slumlord, and it's usually like this person is already on the radar of the police and the prosecutors. And we have seen criminal charges be pressed against owners for being slumlords and allowing their tenants to have a bunch of crimes on their property. Now, is it something that I see often? No, twice in 28 years, but it's a good tool that we can use when you have a landlord owner that has a bad tenant, just letting them know, hey, you can be held criminally liable for the behavior of your tenant. So you really need to step up and evict this tenant. Okay, let's talk a little bit about short-term rentals. That's kind of like the hot topic right now. It's going to be pretty soon here. It'll be January, and we'll have all the snowbirds coming to Arizona for spring training and spring break, and just to get away from the cold and the snow. So let's kind of back up a little and talk a little bit about the history of short-term rentals in Arizona. So prior to 2016, cities, towns, and municipalities had ordinances that prohibited less than 30-day transient rentals in their respective cities. And so basically how they did that was through zoning. So certain areas were zoned as like transient housing, which would be like hotel housing. And then certain areas were zoned as like residential areas where you couldn't have overnight rentals like a hotel because you weren't zoned that way. Well, in 2016, kind of everything in Arizona changed. Everything was kind of turned upside down. And there was a law that was passed that limited a city, town, or county from prohibiting or restricting the use of or regulating based on ordinances or classifications, vacation rentals or short-term rentals. And basically kind of what happened is a lot of these companies like VRBO hired a lobbyist, and they lobbied our legislature pretty hard to change the restrictions so that you didn't have to be zoned a certain way to have a nightly rental. And so that really kind of changed how things operated in Arizona, basically, because it was kind of fair game. You could have nightly rentals anywhere. And, the city's ordinances or regulations were no longer coming into play to regulate, hey, this is zoned as residential only, and you can't have nightly rentals here. And that was out the door. And so now, the city was no longer able to do that. And so basically the result of that was many associations were relying on the city, towns, municipalities to have that zoning so that they didn't have things in their CCNR saying that you had to have a minimum of 30-day rental period or a year minimum rental period, because in most cases, most cities already had that minimum 30-day rental period in a residentially classified area. So when the legislature took away the ability of the city, town, or county from regulating this transient housing and where it could be done, a lot of associations were really in a pickle because they didn't have anything in their CCNRs that prohibited it. So the legislature did put into the statute when they amended this in 2000 that if an association wants to implement rental restrictions or minimum time rental restrictions, they just need to amend their CCNRs to implement that. I think all of us in the industry know amendments to CCNRs don't just happen, right? I mean, sometimes we have 75% approval that's required or 90% approval. And so it really was the legislature passing this law was really kind of a negative thing for associations because it meant that either we had to allow these nightly short-term rentals or we had to get the votes to amend our CCNRs to prohibit them. And in many cases, we can't even get 65 or 70% of people to agree to getting a refund on something. So how are we going to get them to pass a ban on short-term rentals or a minimum rental period? So it really has kind of put a lot of associations in a pickle. Then in 2019, during the legislative session, so 3 years later, our legislature further expanded on the areas where a city, town, or county can restrict short-term rentals, including they prohibited short-term rentals being used for non-residential purposes like a special event or for retail, restaurant, banquet space, event center, or other similar use. So I think what happened is the legislature realized, okay, with none of these zoning restrictions, what was happening is in some residential areas, like event venue people were coming in, maybe during the Phoenix Open or during the Super Bowl, and they were converting a house into a party house. Or we had a situation where there was like a religious retreat at somebody's home in a planned community, and they brought in 300 people and had people parking in the backyard. I mean, it was crazy. So 2019, they kind of, said, wait a minute here, like we are going to allow cities, towns, or counties to have some restrictions on short-term rentals, including you can't be used for non-residential purposes, etc. Okay, let's talk a little bit about some different issues that come up when we have the landlord-tenant relationship. Can tenants attend board meetings? That's a very common question that I get as legal counsel. Or can tenants be a designated agent or the owner or be the owner's representative at a board meeting? Short answer would be no. Tenants cannot attend board meetings unless the board is okay with a tenant attending. Most aren't. Most just want the owners and the association to attend. Along that line too, can a tenant be a board member? Typically no, because typically board members need to be owners, record owners in the association. So sometimes a landlord will appoint their tenant to be their designated agent. I mean, it's not that often, but occasionally we do see that. And if that happens, then the tenant would be allowed to come to the board meeting and they could make a statement on behalf of the owner. They cannot vote on association issues like who's running for the board or a recall effort or anything like that. But they could attend a board meeting and they could speak on behalf of that owner if they have a piece of paper in writing saying that they're the owner's designated agent or donor's designated representative. Can tenants vote? This is a good question. So no, only the record property owners of the property can vote. So kind of the what I would call the $1 million question for today is how can the association get tenants to comply? When you have problems, most of the time, I'd say probably 75% of the time, tenants, they're great owners and they're happy to be living in your community and they're following the rules. But maybe 25% of the time, you may have an issue with the tenant, whether they're parking issues, which we're going to talk about in the second half of this class, or whether they're not they're bringing glass into the pool or having wild parties or not complying with the rules in the association. So how do we get the tenants to comply? I mean, the key thing to remember is the owner is the person that the association has the contractual relationship with, right? So the association doesn't have any sort of a contractual relationship with the tenant. We can't fine the tenant directly for their behavior. Our contract is with the owner. So basically what we recommend is we should have the association first contact the owner in writing regarding the violations. Now, if it's like a health and safety violation, we may be using the phone and contacting them that way or emailing them to get to them quicker. But most violations are like trash cans or glass in the pool or a loud party. Basically, what we recommend is that we send a violation letter first. Typically, the management company or the board may send that first violation letter. And if the behavior is continuing or if the owner is just not responding, then you may want to escalate this by fining the owner for the behavior of the tenant. We have to give notice and an opportunity to be heard under Arizona law before the owner would have the fine levied against the owner. Some other options that you have are we could go to the Department of Real Estate and file a complaint with the Department of Real Estate regarding the tenant or the tenant's behavior. We could go to court and get an injunction. So go to Superior Court, get an injunction compelling compliance to get the owner, to get the landlord to comply, or to get the owner to evict the tenant. Fines are obviously something that are a very smart thing to do, because remember that the owner landlord is in the business of, making money, right? They're renting their property so that they can get rental income in and, either pay down the debt that they may have on the property, or maybe just to meet expenses, or they might be living off of that money. And so if we're fining the owner for the tenant's behavior, the owner is going to start to see, hey, wait a minute here, this isn't working out for me financially anymore because the tenant is now costing me money. So using fines is a very effective tool. Remember, it has to be a violation of the documents. The fine has to be reasonable, and we have to give notice and an opportunity to be heard to the owner before we would fine the owner. Oftentimes, the matter will get escalated to our firm if we have a really bad tenant and an owner who's doing nothing about it. And typically when that happens, I can't think of really one time where we haven't been able to get it resolved with the owner and the tenant, the landlord and the tenant. And basically what I do is I pick up the phone and I contact the owner, and I have a very frank discussion with the owner and just say, listen, these are the problems with your tenant. And usually the phone call goes kind of something like this. Like, I'll contact the owner. Hi, I'm, Beth Mulcahy from the Mulcahy Law Firm. I represent ABC Association. I'm giving you a courtesy call because the board has hired me to file a lawsuit against you regarding the behavior of your tenant. And the first thing that the owner typically will say back to me is, oh, I don't know why the board's so upset about my tenant. My tenant's not doing anything. It's just a bunch of people that are on the board that are nitpickers, or my neighbor doesn't like that it's a rental property or whatever. They usually start with that excuse. And then I'll typically say, well, are you at your desk, or your computer? Can I send you some information? And so then I will send them all of the violation notices, pictures of the property, maybe police reports, if they're police reports that we have. And then I kind of had their ear. They're like, I didn't know that this was going on. And then I start talking about, these are clearly violations of the CCNRs, and we've already levied however many dollars in fines, let's say $5,000 in fines. And if this goes to litigation, it's going to cost, somewhere between $10,000 and $50,000 in legal fees, depending on if this has to go to a jury trial or if this is just an issue that a judge will decide as a matter of law. And at that point, the business antenna is going up on the owner, and they're thinking, oh my gosh, this person who's my tenant is costing me money. And that's right where we want them to understand that. And, at some point it flips, and now the owner is saying, okay, this is a problem. Can I hire you to help me evict them? And that's the way we want this call to be going. I mean, obviously I can't represent the owner, but I can say, you need to look at your lease. Can you terminate the lease if it's, a really bad situation? Or can you get in touch with your tenant and tell them, shape up, or I'm going to evict you? And so that's really the best way to handle these problem tenants is you communicate with the owner, you threaten them with actual legal remedies that we have, make it hurt in their pocketbook with the fines and with the legal fees. And that is the way to get the dominoes to fall, to either get the tenant evicted or get the tenant behaving. Okay, a couple other things. You may or may not know this, but all landlords who are owners in Arizona must register their properties with the state. And so, with the county. So pursuant to Arizona law, and it's Arizona Revised Statutes 33-1902, the owner of a residential property must file a notification to the county where the property is located that it is a rental property. Oftentimes, boards will come to me and say, well, hey, this is a rental property. We know it's a rental property, but then we go and check on the assessor's website and it's not listed as a rental property. And so how do we handle that? Well, you can, snitch on them. I'm going to use that word, snitching on them. You just contact the county or the city that the property is located in and say, hey, this is a rental property and they're not registered as a rental property. And the county and the city, they're concerned about that because they're losing out on all of the taxes that they would make on any rental payment of rent. And there is a civil penalty of $1,000 if the county contacts the owner and they don't, register within 10 days. There's a 10-day grace period. So, the purpose of this law is to make sure that the county is aware which properties are rented and that the property taxes are properly calculated and paid by the landlord owner. Also, House Bill 2672, which is a kind of somewhat recent law, also requires that an owner of a short-term rental property provide the city or town and the county with contact information for the owner's designee who is responsible for responding to complaints regarding the short-term rental in a timely manner before offering to rent the property. So what I would do is if we have landlord owners that are listening in on this call, or even if you're an association or a property manager that's listening in, know that not only do they have to register with the county, which is a very simple registration process, but they also, many cities, towns, and municipalities and counties in Arizona have a specific short-term rental, ordinance that talks about different things that the cities require the landlord owner to notify the city about. And some of them have a requirement that they have to, have a sign on their property that it's a rental property. Each city has different requirements. So we want to check, maybe have the board members check or the property manager check for the city that your property is located in to see what their requirements are and then make sure that the owner or landlord is complying with them. Okay, what are some solutions if you've got really serious problems with a rental in your community? So some things to consider about if you've had problems in the past, maybe you want to do an amendment to your CC&Rs to restrict short-term rentals. There's a case that was decided a couple of years ago, the Hallway case, that's making it more difficult for us to implement rental restrictions, rental restriction amendments, but there's ways that we can do it to grandfather existing owners and maybe have it only apply to new owners. That would be a successful way, workaround on Hallway. So a couple solutions would be, okay, if we don't want short-term rentals in our property anymore, maybe we consider doing an amendment to our CC&Rs to get rid of short-term rentals. Another really important thing that you should be doing is documenting the file on any tenant issues. Make sure you're taking pictures. Make sure that there's a write-up of any event that occurs relating to the tenant that might be a violation of your documents. Any police reports, get a copy of those. Any letters that the association or management company is sending to the owner regarding the tenant's behavior. All of that needs to be kept as documentary evidence that we can use to show the landlord that there's a lot of bad things happening in the property and violations to the documents. Or it may be used in an ADRE hearing at the Department of Real Estate or in Superior Court if we're filing for an injunction compelling the landlord to comply. Another thing I talked about a little bit, if you've got issues with a rental property, pick up the phone and call the owner landlord. That's been a very successful tool for me to get landlord owners to comply and be very polite and courteous, but be very firm that, hey, these are the next steps we're going to be taking if you don't either get the tenant to comply or unless you evict the tenant. Now, remember, a lot of times I'll have clients call me and say, I just want you to tell the landlord owner to evict the client, or I want you to make them evict the client. I mean, I don't have a contractual relationship with the tenant, so I can't make anybody do anything, right? But what I can do is push the right buttons to get the landlord to evict the tenant. And we do that again by using fines, by letting the landlord know that, hey, we're going to pursue our legal remedies against you if you don't resolve this, including the criminal penalties that we talked about a few minutes ago, or civil penalties, filing a lawsuit against you to collect fines, getting our attorney's fees for having to file the lawsuit, getting an injunction compelling you to evict the tenant or to get the tenant to behave. Let's see. Remember that the best way to get the tenant to comply with the association's document is to make it hurt in the landlord's pocket through fines. And the last resort, even if a phone call doesn't work and we don't get the landlord to comply, is to consider going to Superior Court, getting an injunction against the landlord owner. And you'll be entitled to your attorney's fees, reasonable attorney's fees as part of that, because it's going to be breach of contract on the part of the owner. Another alternative would be to go to the Arizona Department of Real Estate and file a complaint against the owner there and have an administrative law judge rule on whether or not the tenant is violating the association documents. So lots to think about with rentals and an association. I think kind of gave you a good little 411 on the different things that you need to be aware of if you're managing rental properties and dealing with rental properties in your association, how to best handle any problems that come up. And just kind of a closing thought, I like to kind of end things positive on topics. There are a lot of great renters that live in an association. So I don't want to make it look like, I'm biased against rentals or anything like that. I just want to have you have the tools at your fingertips. So if there are problems, you know what different alternatives you have to get the owner to comply. Okay, let's talk next about parking and parking headaches. I would say, we tried to hit two kind of hot topics today. Rentals are definitely a problem area for associations. The next kind of more problematic area is going to be parking headaches, and how do we handle parking issues in an association? And there's all kinds of different parking issues that associations have. I mean, it kind of depends on how your association is set up and how many parking spaces you have and how wide your streets are, et cetera. But kind of the first thing that I would say is if I get a parking issue come into our office, what I would recommend is that we always look at what do the documents say about parking? What do the CCNRs specifically say? Do they not allow on-street parking by overnight, or do they only allow it by guests that are there for less than 6 hours? Or, how is the configuration of your condominium or townhouse set up? Is it, if you have extra parking spots that are not designated to an owner, who's allowed to park there, et cetera? And so what I always do is I try to do a deep dive initially, like what do the documents say? What's in writing regarding the parking, because that's going to be really important about, how we enforce things. And what exactly does the language say? Like, is it strictly prohibited, or does it use language like it's recommended that people don't park in their driveways? Well, recommended isn't that strong of language. So first thing I want to do when we are looking at parking issues is look at what do the documents say about parking, and look at the language and then find out what the problem is. Like, what's the issue that we are dealing with on parking? Okay, there's a very important law that I want everybody to be aware of because there's a deadline coming up on this law too. And basically, it was signed into law in 2023, and it requires communities to assess parking regulations before June 30th, 2000 deadline. And so basically, this law was passed by the Arizona State Legislature. It's in Arizona Revised Statutes 33-1818, and it only applies to planned communities with public roadways. And so a lot of associations are wondering, like, hey, does this law apply to me or does it not apply to me? And why is it important is because if you're one of these associations that this law applies to and you don't take a certain action by the June 30th, 2025 deadline, you will no longer be able to enforce parking in your association on these publicly owned streets. So let's start out with the kind of the first step is, how do we know, does this law apply to our community or not? And so it only applies to planned communities that meet all of these criteria. So it has to meet all 5 of these things in order for this law to apply to you. So first thing, the planned community is no longer under developer control, number 1. So no more developer control. Number 2, the CCNRs were originally recorded before January 1st, 2000. The CCNRs, number 3, the CCNRs include on-street parking regulations. So have street regulations, parking regulations in your documents. And 4th, the communities within the community are public. So the roadways are dedicated to the public. So it's like the association doesn't maintain it, but it's not responsible for maintaining it. And then if the planned community meets all 4 of these requirements, the existing on-street regulations will remain in effect only until either of the following occurs. So if you meet these 4 specific criteria, again, not under developer control, your CCNRs were recorded before January 1st, 2015, you have on-street parking regulations, and the roadways are public roadways dedicated to the public in your community, no later than June 30th, 2025, your association must call a meeting of the membership on the question of whether to continue to regulate the public roadways. If a quorum of the membership is met at that meeting and a majority of the owners voting at that meeting vote to continue regulating the public roadways in the planned community, then the planned community can continue regulating the public roadways. And if that happens, the board has to record in the county recorder's office a legal document confirming that the planned community is going to continue to regulate the public roadways. This is just kind of like a weird law. I think basically I think what happened is there's always been kind of like a question as to, okay, if the streets are dedicated to the public, how can the association enforce parking on the street? And it is kind of a sticky wicket. There's a case out of Missouri from many years ago that talks about this exact issue. That a lot of times it's called Maryland Estates versus Puckett, or Puckett versus Maryland Estates. I can't remember. Those are the plaintiff and defendant names. And in that case, basically what the court ruled was, okay, the association can enforce parking on a publicly dedicated street because the association has a contract with the owner. And the owner is required to abide by the CC&Rs. And so even though the streets are public, it doesn't matter. We can enforce whatever restrictions are in the CC&Rs. However, I think the gist of this law is, okay, the streets are dedicated to the public. If the association wants to continue regulating the on-street parking in a planned community that's past declarant control, where the streets are dedicated to the public and the CC&Rs were recorded before January 1st, 2015, you're going to have to do this vote. And surprisingly, we have a lot of associations that fall into this category. Maybe it's because people, we aren't close enough to the deadline yet, but maybe we have, 10 out of 1,000 associations that we represent. And I don't know how many actually fall in this category, maybe 400 if I had to guess, have opted to have this vote. And surprisingly, it's passed on every single one that they've taken the effort to have the vote so far. And so it's just something that I would like all of you who this applies to keep this on your radar, because this isn't something that you can just do on June 1st, because we have to have a meeting of the membership. So you really need to make a decision on this by at the absolute latest March 1st. That you're going to proceed forward with the vote if you want to continue regulating on-street parking, if your streets are dedicated to the public and your planned community. Now, what do you do if you don't have this vote? Or maybe you try to have the vote and it fails? What happens? Then on July 1st, 2025, guess what? The planned community no longer has the authority to regulate the public roadways in the planned community. And any existing parking regulations that you had in your CC&Rs will now expire and you will not be able to enforce them. So just kind of a very important piece of new legislation that you need to have on your radar for going into the next 6 months. We've already started helping planned communities, like I said, about 10, navigate the compliance with this new law from the beginning to the end, from consulting with us to conducting the vote to recording what needs to be recorded with the recorder's office, saying that we're going to continue to enforce our parking restrictions. We're here to help you if your association falls under this category and you need help navigating this process. So please reach out to us soon, because you need to start working on a plan so that you can comply with this by June 30th, 2000. We have a firm blog that we wrote on this exact topic, which we're going to be sharing with you. So I encourage you to take a look at that. Okay, let's talk a little bit about what are kind of the most common parking issues that we see in associations as violations. First one is going to be overnight on-street parking. Really difficult to enforce because sometimes people are parking there at midnight and beyond when we don't have anybody patrolling in the community. Also, illegal parking of RVs, campers, commercial vehicles, boats, trailers on streets or common areas or on an owner's property in violation of the documents. What are the best way to handle parking violations, in our opinion? Well, first, like I said at the beginning of this, check the documents. What do your documents say about parking? Is what they are doing a violation? Question to think about would be, who will document the parking violation? Is it going to be a neighbor? Is it going to be the board? Is it going to be a security patrol, a manager, a company that you hire to come in overnight to patrol your streets? Whoever is complaining about this or whoever's documenting the parking violations, make sure that we have really good evidence. Like, we should get a picture of the vehicle. We should get a picture of the license plate number. A very common thing that we have happen with overnight parking is everybody says it wasn't me, right? They say, it's not me. That's not my car. I don't know what you're talking about. If we have the license plate number, our firm can check with the DMV and find out who's the actual owner of the vehicle. And typically, we already know from the owner because if an owner's complaining, they know exactly what's going on. It's Johnny so and so's girlfriend's coming over at midnight. It's her car. It's not his car, but she's a guest. So we obviously, we usually don't have too much trouble sleuthing who the car belongs to. What are the enforcement options that we have? I think any management company, we have a number of management company representatives here today. I think the number was like 15% or 14%. Anybody who's in the management industry knows, okay, parking is like a major headache because it's hard to prove who is doing it. Sometimes it's the manager's not there 24/7, 365. So we kind of have to rely on the documentation that's provided to us. And it's a problem that never goes away. It's like you can never totally clean up the problem. So it's frustrating for management companies. So a couple things, just some reminders would be really good communicators to your owners about what's allowable for parking and what is not allowable. Put it in your newsletter, talk about it at board meetings, talk about it at the annual meeting, so that people are aware of what is acceptable and what is not acceptable under your documents. Also start out with doing letters. Maybe you do a courtesy reminder letter first and then escalate it up to like a violation letter. And then maybe you're fining the owner and then maybe it goes to the attorney. These are the different steps that escalate on the parking. And then who knows, maybe we escalated even further to filing a lawsuit in Superior Court against the owner or going to the Arizona Department of Real Estate and having an administrative law hearing on whether or not the owner is in violation of the parking restrictions in the association. Some associations, like I said, rely on documentation from the other owners regarding the parking violations. Some associations hire a patrol car to cite cars. One thing that I'm always kind of a little bit wary about is towing. Do not tow if you're an association unless it's in your documents that you have the authority to tow. And even if you do have authority, be careful on it because there's all kinds of bad things that can happen when a car is towed. It can be damaged. Usually there's a lawsuit. They have to pay a big impound fee to get it out. And you have very unhappy owner when that happens. A very effective thing that many associations use is the sticky stickers on the driver's window that let them know that they're in violation. They're difficult to get off. And a lot of associations use those. Some associations are using wheel boots or similar devices to incapacitate the car versus having it towed. And then, of course, our legal remedies would be if after sending violation letters and having me pick up the phone and call the owner to talk about the problem, the last resort would be to file a lawsuit, in Superior Court to get an injunction compelling them to stop doing that, or to file a complaint with the Arizona Department of Real Estate to have an administrative law judge rule that this is a violation of the documents. Briefly, let's talk a little bit about electric vehicles, just because there's a lot of questions in our industry right now about what do we do if we have an owner that wants to park their electric vehicle and charge it or whatever. Typically, this is not going to be in a planned community because in a planned community, if somebody has an electric vehicle, they have a charger at their home and they're not looking for, like a place to charge their vehicle. They have it right in their garage or on the side of their house or whatever. We typically see the electric vehicle charger questions come up in townhomes or condominiums where there is no place for them to charge their vehicle. And maybe they want to put in a charger next to their assigned parking spot. They just need to work with the board and make sure that what they're putting in is safe and, that it will be maintained by them. Really, I'm not seeing a lot of associations right now spending money to put in a charging station that everybody can use in their association because there really isn't that much of a need in my experience, or it's not like 80% of the vehicles in an association are electric. It's usually like there's a handful in a condominium. And usually those people know that when they buy it and they charge it somewhere else at work or at the shopping mall or at the city or wherever the fast chargers are. A couple things to think about would be if you are going to put in, an association is going to put in a charging station, you want to make sure you do it in such a way that, the person that's charging it pays to charge. so that the association isn't stuck paying that fee. Are you going to have to give up a designated parking spot to make it a charging spot? That could be controversial, especially if you don't have enough parking for your guests in your community or for your owners in your community. If you're facing this question, I would definitely recommend that you reach out to our firm and we can help you navigate this process. We have a sample electric vehicle policy that we give out at free for condominiums and townhomes. And it kind of helps you navigate like what are the different issues you should be thinking about as an association if you're going to put in an electric charging station or if you're going to allow an owner to put one in their property. So that's just a quick overview of parking. And we're going to go right into our questions right now. It looks like I'm 1 minute over. It's just about 12:01. It looks like we have, a lot of questions today, about 30 questions. So we'll dig right into our questions. Our first one is from a board member. Can an HOA issue a violation for any reason if a board member observes and/or documents it, but the property manager doesn't? Is the board member's name subject to disclosure if requested by the violator? We do provide a complaint form for residents to file violations, which include applicable statute 33-1242 for disclosure. Okay, so yes, I do feel that the association can issue a violation based upon a board member observing the violation. Ideally, it would be best if a board member or a property manager, one of you has to see the violation. Now, if it's an owner, I would need to have like evidence, like a photo or something to support the violation before I would advise the board to send out a violation letter. Is the board member's name subject to disclosure if they're the only person that, saw the violation and it's in the association's records? Yes, they would be. Same thing with an owner. So if the violating owner wants to know who made the complaint, the association does have to provide that information as to who witnessed the complaint. Okay, next question. Let's see. Is the association required to have an audit done yearly? So yes, an association, it's a planned community or a condominium, has to have an audit, review, or compilation done every year. The audit only needs to be done by a CPA if your documents require it to be done by a CPA. Otherwise, anybody could do the audit, review, or compilation based on the loose language of the statute. And if you want more information on that, our top 10 cheat sheet on our website has the statute number and a little bit more analysis on the audit for you. And remember that the audit, review, or compilation for like the 2024 books will need to be completed by June 30th, 2025. Okay, next question. Our master association, maybe it says should be held the annual election of the board. There were 3 openings, but only 2 candidates on the ballot. There was no line for write-in votes, but members added write-in votes for 1 member in the blank space below the 2 candidates to fill the 3rd position. The board will not recognize this write-in vote because there was no line for write-in votes on the ballot and plan to appoint someone to fill the opening. Our governing documents state that the board members are to be elected by association members. Our master association appears to be in violation of those documents. What recourse do we have? This is a tough one. I'd like to see the ballot, but I do kind of feel like, if there were 3 openings and it said, hey, we're trying to find 3 members to serve on the board, I don't really understand why they wouldn't accept the write-in candidate. If your documents prohibit write-in candidates or something like that, or then maybe they'd have an argument on that, but I'm not hearing that based on the facts you gave me. So if I were you, I would request to see the ballots. I'd ask for a copy of all the ballots so that you get a copy of the people that wrote the write-ins. I would hire an attorney that represents owners to send a letter to your master association, telling them that, hey, we think these people were elected, and by appointing someone to fill these spots, you potentially are violating the will of the people, and see what they do. If you want the name of an attorney that could help you to send this type of a letter, an attorney that only represents owners against associations, just reach out to me and I'll be happy to give you the name. I think that's probably the best way you should handle it. Okay, next question. Is the HOA required to obtain proof of insurance from owners and renters? If so, how often? Unless it's in your documents, you're not required to obtain proof of insurance. So, and if it is in your documents, it should be annually, but really you should have the association should be an additional insured on the owners and the renters policy so that we are aware if you cancel it at any time during the term of the, agreement with the insurance company. Okay, question 5. My association is hoping the CTA will go away. Since I'm the director, can I file just for myself? So I think we're all hoping the CTA will go away, myself included. Really, the association needs to file. You can't just file for yourself. Everybody needs to comply with this law. So just putting one board member's name down and filing it, it's not enough. We need to have everybody who's on the board. Okay, next question. My HOA is not incorporated. Do we need to file for the Corporate Transparency Act? So there are a few exceptions. I don't know. I'd have to look at your association on a case-by-case basis. It's possible you do not have to file because you're not incorporated, but I don't want to give you that answer here based upon the penalties without looking at your documents. Okay, question 7. Our roads are private. We are preparing to enforce our parking rules. Our CCNRs say no residents, guest parking only. Our signage says homeowner parking, guests only. Do we need new signs because homeowners don't include renters? We've been told warning notes under windshield wipers and towing are necessary because Phoenix doesn't allow driver window stickers and booting. Is that true? Our CCNRs allow booting or towing, and warning signage will be ordered. Okay, a lot to swallow here. Okay, so you've got private roads. You want to enforce your parking rules. Our CCNRs say no residents, only for guests can park here. But your signage says no homeowner parking, guests only. Well, I think you should change your signs to match what your CCNRs say. That would be my first suggestion. I'm not aware that the city of Phoenix doesn't allow driver window stickers and booting. So I would recommend that you reach out to the City of Phoenix Neighborhood Services Department to find out what their policy is on that. Okay, question 8. Can the board legally have a member in an owner's meeting removed due to that person being verbally abusive, calling the board names, filibustering the meeting so that important information is not able to be given to the owners, and now most of the owners will not come to the meetings? Can we require a form to be signed by each owner stating they will be removed if they are verbally abusive? So we have a great cheat sheet on this topic called Dealing with Difficult Owners. You can find it on our website at mulcahylawfirm.com. Just click on the cheat sheet tab. I guess from my perspective, here's how I would handle it. If you have an owner who is being verbally abusive, perfect example here is the information that you're giving me. A couple things you could do. If you want to continue having in-person meetings, you could just announce at the beginning of the meeting what the rules are for the meeting and include that all these things that this person is doing, that if it happens, the person will be asked to be removed. If they won't leave, we'll call the police or we'll stop the meeting. That's one option, right? And then do it. If you're going to threaten it, then you have to say, if this behavior happens, you'll get a warning and then you'll be asked to leave. If you won't leave, we'll call the police. You may have to actually do that once. Another option would be just convert your meetings to Zoom. And if somebody starts behaving like this, just mute them. Have the person who's controlling the Zoom call, just mute them or remove them from the meeting. And that will handle the problem right there. Can we have a form to be signed by each owner stating they will be removed if they are verbally abusive? The sad thing here is I've gone to probably, I don't even know how many meetings over the years, probably 10,000, 15,000 meetings. The people that are going to sign that form are going to be the ones that are behaving. The bad egg who's misbehaving will never sign that form. So I don't think that form is something that is going to work. Okay, next question. Can the HOA prohibit renters from subletting their condo? So it depends on what your documents say. By subletting, I'm guessing you mean like renting a room or something like that. So it needs to be in the CCNRs, whatever you're trying to prohibit somebody from doing, whether it has to be single family housing or we're not going to allow subletting. We see situations where maybe it's a rental property and maybe 3 unrelated people are living in the property. And that's not going to be considered a violation of the single family housing. So we'll have to kind of look at, what your issue is and what the CCNRs say, and then evaluate what's the best way to handle it. Okay, question number 10. What is the process for obtaining a change in the plat map based upon the Superior Court decision in Sackett versus EPA, which is regarding the waters of the U.S.? The case concluded that natural washes that flow solely from precipitation and having no direct connection to navigate waters are not subject to EPA jurisdiction. Original plat map contains restrictions that are in part based upon now supersede federal laws and regulations. I probably wouldn't touch that with a 40-foot pole. I don't think that you can probably change the plat map for that purpose. I have to look at it maybe a little more carefully, but I mean, the plat map has been in existence since the beginning of your association, and I'm not sure that you're going to need to change it based upon this decision in the Supreme Court. But you're welcome to reach out to our firm. I can take a look at the plat map and see what it says and give you a more detailed opinion if you'd like us to. Okay, next question, number 11. What is the $15 late fee and when can it be charged? Okay, so remember, we're going to flip back to what we talked about earlier in the presentation today. So when we're asking the landlord owner for information about their tenant, right, there's only 4 things that we can ask for, like the names of the adults living in the property, how long the tenancy is going to be, the vehicle description and license plate numbers. And then we can charge them a $25 fee for providing us with that information. And and if they don't pay that $25 fee after we've given them 15 days to pay it, and we've got proof that we sent it to them by U.S. mail, that we asked them to pay it, provide us this information, then we can charge the $15 late fee for them not providing the information. Okay, next question, number 12. Please clarify, HOAs cannot fine for failure to submit rental registration. We can only charge a $25 fee and then a late fee for not providing it of $15. That is correct. We cannot fine an owner, landlord, for not submitting the rental registration form or the rental registration information, right? And again, it's just that those 4 categories of information. If they don't submit that and they don't pay the $25 fee, after we give them 15 days notice by U.S. mail, if they don't pay it, then we can charge the late fee. Okay, question number 13. Can the assessment statement be mailed to homeowners so we can save on postage? Or can it be emailed to homeowners so we can save on postage? This is a really good question. This kind of is another law that was passed maybe 4 years ago that says that we have to send an assessment statement to owners to let them see their balance. It really does need to be by U.S. mail unless the owners have opted in to receive it by email. Okay, question 14. If the homeowner fails to register their tenant, can you restrict the tenant's usage of the common amenities? Ooh, that's a good question. I don't think so. And here's why. Because it says under the statute, let me go back up here. If we go back and look at the statute, let's see. So you go back and look at it, it says, except for the fees allowed to obtain the tenant's information, so $25, and any fees that relate to the use of recreational facilities, the association or its manager cannot assess, levy, or charge a fee or fine or otherwise impose any requirements on an owner's rental that are different from an owner-occupied unit in the association. I mean, I probably wouldn't. I would just stick with the $15 fine based upon what this statute says. I don't think I would go into, we're not going to allow you to use the amenities because you didn't register the tenant. I think it's pretty clear that we can only charge that $15. So it's a little bit of a gray area, but I would lean on the side of being conservative and say, don't do this. Okay, question 15. Is there a limit on how many level 2 and sex offenders that can live in one 4-bedroom home? Wow, that's an interesting question. I am not aware of any sort of limit like that. You could probably check with your county or your city to see if they know the answer to that. Question 16, I am a board president with a board member who is behaving in a manner that is toxic, bullying, and backstabbing. This person has been spoken to about this behavior, and the person is not complying. Thoughts, please. Okay, so you're the president. You've got a board member that's a problem, right? My thoughts would be, is this person an officer? If they are, strip them of their officer title by having the rest of the board take away the officer title. If it's not an officer title, the only way to remove this person from office would be to follow state law. And that would require like a petition of the homeowners and then meeting of the membership to remove the person from office. I don't know how long their term is. But I think what you should do is maybe consider having your attorney come in and give a boot camp. Our firm goes in and does boot camps to help boards that have a high level of dysfunction because of someone like this. Another thing would be to have the attorney write them a letter regarding their behavior for the association. The attorney for the association sending the board member a letter telling them breaching their fiduciary duties, you're causing a lot of problems. So I think there's some good suggestions there. So consider having a boot camp to bring all the issues to the table and talk about them as a board with maybe our firm to help you. Have me write a letter to this person regarding their behavior, reminding them that they're breaching their fiduciary responsibilities. Do a removal meeting to remove this board member from office. Or the fourth option would be don't vote them out, but the next meeting, make sure that when their term's up, that they're not being elected by, bringing in a good candidate and trying to get other people to vote for this other candidate versus voting for them. Okay, question number 17. Our CCNRs mention owners must park in garages. All parking spaces shall be available for use by members of owner's family, their guests, and their tenants. But in the rules, the following is stated: any vehicle that is parked in violation of the parking restrictions identified in the CCNRs and association rules is subject to towing. They give each owner a visitor pass. If you don't have a pass, the HOA is towing without notice. Is that a valid policy? So your CCNRs say owners got to park in the garages. Parking spaces can be used by members of the owner's family, their guests, and their tenants. But the rules state that any vehicle that is parked in violation of parking restrictions is subject to towing. Okay, I don't think that the towing is a valid policy just being in the rules. So that would be my advice. I would not be towing based upon that only being in the rules. I think that is not good legal justification, and the board should not be doing that. Okay, question 18. What can an HOA do if the person who is committing a crime is a homeowner? SWAT was called and he was booked and pleaded guilty. Okay, well, I'm guessing maybe this person's going to jail if they pleaded guilty, but who knows, maybe not. So if the person is committing a crime and they're the homeowner, you can fine them. Would be one thing to think about for the nuisance that's being caused. Maybe you could get an injunction compelling them not to do it. I'd probably need to hear more. It's concerning to me that the SWAT team is out there and this person is in jail. They pleaded guilty. Maybe they're in jail. Maybe they're going to be back, and you just want to make sure it doesn't happen. But I think fining them for that occurrence and setting expectations going forward will be important. So reach out to my firm. Maybe I can help with that. Okay, next question 19, does an owner's designated agent or a renter have permission to attend board meetings? So owner's designated agent in writing, yes, they can attend a board meeting. Renter, no, they cannot attend a board meeting unless the board allows them to gratuitously, or unless the renter is appointed in writing as a designated agent to go to the meeting on behalf of the owner, and that form has been provided to the board. Okay, question number 20. Our condominium is midway through board elections. The association altered candidate applications by removing all paragraph breaks without candidates' knowledge or consent. This was a secret policy which caused compositional errors in some candidates' biographies. Management and board refused to address this or issue corrections. What are options for candidates' remedy in the case of harm to one's candidacy? I mean, just because they took out the paragraph breaks, I wish they hadn't done that, but they may have done it for spacing to try to fit it all on one page or something. I don't know. I think the candidate's remedy would be send out another statement on your own dime to make a better presentation as to, whatever you want to say to the community. But I don't think that, you can force the association to do that unless they gratuitously agree to do it. Okay, question number 21. For 1 and 2 night renters who are violating the rules, how can we keep up with violation notices when it's happening frequently? Is there a single violation notice and then after that a fine for each tenant who is breaking the rules? I think on this one, you really need to kind of take a peek at, okay, we need to get in touch with the owner. We need to have a face-to-face or one-on-one phone call and just explain to the owner that, okay, we know you're having people coming in and out of here on a nightly basis. This is what you need to do with the association, and you need to pay the $25 fee. You got to give us the information on your 1 and 2 night renter. And if you don't, here's what's going to happen. We're going to file a lawsuit against you. We're going to go to the company that is doing all these rentals for you, whether it's VRBO or whatever, and we're going to subpoena all the records. and you're going to have to go back and pay, all these fees, and then also pay all of our attorney's fees. So I think the best way, it's hard to keep track of, okay, the neighbor saw somebody coming in on Saturday and left on Tuesday, and then another neighbor. It's too hard to do it that way. You have to get buy-in from the owner to make this successful. And so I think the best way to do that would be to have the attorney reach out to the owner, let him know these are the violations, and this is how much it's going to cost you if you don't comply, and let them know that we know you haven't been complying, but this is what we're going to do unless you comply going forward. Next question, 22. Can a maximum dog weight that is written into your CC&Rs be upheld? Or will that be something that is against their rights? This question is only for standard pets and not in reference to service dogs or any other type of special needs animal that a tenant or owner would need. So yeah, I think if there's a maximum dog weight that can be upheld, is it a good idea to be enforcing that? I guess that's kind of in the eye of the beholder. Dogs gain weight sometimes over time, or dogs gain weight if they have a health issue, and pets are kind of almost like children for people. So to tell somebody they have to get rid of their pet could be really a difficult situation. And so from a practical standpoint, can you enforce it? Are you willing to enforce it? Is it going to cause a lot of unrest to enforce it with an owner? Probably. But can you legally enforce it from a contractual basis? Yes. Okay, question 23. What is your opinion regarding having one of our security cameras installed on our clubhouse that would view the 2 pool gates only? The camera would view only people entering and exiting the gates. We have a board member who claims this is an invasion of privacy. I don't have any issues with that at all. As a matter of fact, almost every association that we know of has cameras at their pool, or a great majority has cameras at their pool for a number of reasons. And so I don't have an issue with that. 24. I heard that TPT rental tax is being eliminated January 1st, 2025. Is this true? Will the landlord owner still need to report rentals if this is the case? Okay, so my office did some quick research on this for me, and we're going to be sharing with you a link on the transaction privilege tax. Based on my office's quick research, it is true that the TPT tax on residential rentals is being eliminated in Arizona, effective January 1st, 2025. Properties must still register their property with the county assessor's office. And then check the link if you want more information on this. Okay, question 25. Looks like we have a total of 33 questions, so only a few more. If 2 out of 3 board members request a special meeting be held and the specific topic is RFP review and decisions, but the 3rd board member and management company do not acknowledge the request, can the meeting be scheduled, noticed, and held? So my opinion, I'd have to look at your bylaws, but yes, I do think a majority of the board can call a special meeting and you should be able to move forward with it. Okay, and just do it without them. If they're not willing to come, or they're not willing to acknowledge it, then you just post it at the property and make sure you post the notice of the meeting and an agenda, and then state with particularity what specifically is going to be discussed on the agenda. Okay, question 26. How long do board meeting minutes need to be saved for? We have a great cheat sheet on this called document retention or records retention for associations. Meeting minutes are permanent and they should be saved forever. And so do not terminate, do not get rid of those. That's the history of the association. You keep those forever. Question 27. We had a current board of 5 members and 1 board member just immediately resigned, leaving us with 4. Do we have to fill that before the end of their term? It depends. It depends on, do your documents say you must have 5 board members? Like, how quickly is your annual meeting coming up where you could, elect somebody for that spot? Or do you want to appoint somebody? There's a lot of variables. So do you have to fill that? Probably not, but I wouldn't leave that open for too long. And I want to look at your documents to see what your documents say about this. Okay, question 28. Regarding for sale signs in common areas, a realtor is referencing a statute saying that owners in a condo complex own an undivided interest in the common areas, so they can put a for sale sign out in the common area. The statute states that HOAs can't keep owners from putting up signs on their private property, which we don't believe includes the common areas. I know this has come up before, but the realtor is saying we need to get a letter from the attorney or they won't remove the sign. What are our remedies? Okay, so I don't know specifically if you're like a condominium or planned community. It probably doesn't matter, but okay, if a realtor, okay, so here's what the law is on for sale signs, and we have this on our top 10 cheat sheet. If you want more information on that, top 10 laws pertaining to Arizona Community Association law. Okay, so each owner can have a for sale sign on their property. They cannot have it on common areas. Okay, if it's a condominium on their property, means in their window or maybe in their limited common area. But it doesn't mean that you can put it on the corner leading into the association, etc. So if the realtor put it on the common areas, I mean, you want to get along, but you can also say if you don't remove your sign by X date, this is what we will be doing. If you want the statute number, go to our cheat sheet. Like I said, our top 10 cheat sheet, and it's listed on there, I think on the back side of the number 7 or 8 on our top 10 cheat sheet. So you can remove it because it's on your property, but you probably don't really want to do that because those signs are heavy and expensive to move. What I would say is tell the realtor to move the sign by X date, and if they don't, then you will have it removed. Okay, can we have the public roadway vote at our annual meeting? So good question. Yes, you can. Number 30, what is the best approach to deal with homeowners who refuse to comply with the community sign guidelines or new laws regarding the removal of election signs on their property? As a board member, we are responsible for upholding the guidelines, but we do not want to turn this into a potential media fiasco. Amen. I agree. I would give them a reasonable period of time to remove the signs. And so I would say before Thanksgiving to me, I mean, the national election took place quite first week in November. So the signs should be down. You may just want to make an announcement via the community if you have a lot of people that still have flags up or signs up or something like that. Just remind them that the law says that the signs should have been removed by now. And if they don't remove them, they will be receiving a violation letter. And I don't think that should be a potential media fiasco because the election's over. And even the cities, all the signs that we had all up in the city corners and all that stuff, that those are all should be removed by now too. Okay, question 31. Do the renter name, contact, duration, and car info rules apply to short-term rentals that may only be there for a few days? So short answer, yes. Question number 32. Please clarify if an HOA needs to proceed with an amendment in order to find an owner whose renters are causing our HOA to receive constant complaints about aggressive behaviors. Another has suspicious drug usage, selling activity, and the police have been involved. So I don't think you need an amendment to find an owner if you have a renter who's causing a nuisance. I mean, 99.999% of CCNRs have a provision in there that talks about nuisance. And so I don't think you need to do an amendment to deal with this issue. It's probably already in there. Okay, question number 33. What can be done after a denial of a paint color when the owner appeals without making any change? We are a tan, desert-colored community in general. We do have designated color palettes, but we also allow submitted colors if approved. Owner is asking for an almost navy blue main home color because light blue has been allowed in the past, but not on a designated color palette. Well, I mean, paint colors are always a nightmare, especially if they've already painted it because it's expensive to paint. But I guess what can be done, you can either live with it as a board. You can force them to repaint it because they didn't get approval and it's not a color that would have been approved. You can, by forcing it, I mean, you could go to Superior Court, get an injunction compelling them to paint it. You can go to the Arizona Department of Real Estate and have an administrative law judge rule that what they did was illegal and it needs to be repainted. You can let them keep it and say when you sell your house, it has to be repainted. I mean, there's a lot of different things that you can do. Legal, be more accepting of it if that's the route you want to go, and just say when they leave, they sell their house in the future, repaint it, it needs to be repainted. I mean, there's a lot of different options here. Okay, and our last question, number 34. Our HOA has not had an election for years. There was a majority vote when 2 members were unable to vote to sign up for a property management company. The 2 members have been reinstated. It was due to delinquent dues, but there still has been no vote. And they continue to contract for an additional year with the property management without a vote. The property management company now calls themselves the board of directors. What can be done? Okay, that sounds like this is very dysfunctional. So, I mean, if I were in your shoes, I would write a letter to whoever's acting as the board and tell them that you want to have an annual meeting. We're required under Arizona to have an annual meeting. ask them to have an annual meeting, in January, because right now we're kind of in holiday alley, and I don't think it's a good idea to ask for it right now until the beginning of the new year. So ask now. We're demanding an annual meeting for our association. We haven't had one. We're asking that it be conducted in January or February 2000. And if you don't notice it, we will notice it as homeowners. And then after, it's noticed and a ballot is sent out, then you got to go door to door and get people to vote, because it sounds like they haven't had an election for many years, maybe because they haven't been able to get a quorum. So you're really going to need to find good candidates to run and then get people to vote to get them elected. Okay, that's it for today. We had 34 questions, amazing turnout. It's hard to believe that this is our last Tuesday neighborhood services, Virtual HOA Academy of 2024. We've had 11 classes so far, but this is our last Tuesday session. So our last class of the year is class number 12, and that's going to be held as part of the 2000 Virtual HOA Condominium Academy. It's going to be held in collaboration with our firm's live virtual First Friday event, and that will be taking place on Friday, December 6th at 9 a.m. This will be our last virtual class for 2024. Where has the year gone? Crazy how fast 2024 has gone by. Tomorrow evening, Hayden DiLorenzo from our firm will be presenting in person on enforcement at the Surprise HOA Summit. If you want to have more information on that free class, you can visit our firm's website at www.mulcahylawfirm.com. I will not be seeing you again till Friday, December 6th. So I would like to wish all of you a very happy Thanksgiving. And I look forward to seeing you in December for our First Friday event on December 6th. Take care, everybody, and have a happy and safe Thanksgiving with your family and friends. Take care. Bye.
Don't forget, our free cheat sheets are available for download at mulcahylawfirm.com.
The intent of our Zoom, Facebook Live, First Friday free call-in, videos, and podcast is to provide a forum for board members and community managers to receive answers to HOA and condo legal questions. Please note, the content in these sessions are general in nature and is not intended to and should not be relied upon or construed as legal opinion or legal advice regarding any specific issue or factual circumstance. You should directly consult with an attorney for advice regarding your individual situation.